The European Convention on Human Rights applies to every individual human being, irrespective of their gender, ethnicity, sexual orientation, nationality, etc., etc. The European Convention was a revolution. It is a revolution.
Some people say that the European Court has gone too far. It shows disrespect for democratically elected governments. It's micromanaging situations that should be left to governments. Others say, no, hang on, it's a living instrument. What do you expect a court to do? It can't be stuck in the 1950s. It's got to interpret the Human Rights Convention according to the needs of the people, according to the cases that come before it.
The European Convention on Human Rights was signed in 1950, so it's not a new baby, so to speak. And of course, when the individuals and states who drafted the convention did so, they did so against the context and the background of the world as it was in the late 1940s and the early 1950s, including the values that pertained then. And so the court has adopted an approach which treats the European Convention on Human Rights as a living instrument, that is to say, a treaty which is to be interpreted in accordance with values as they evolve over time.
A convention that was drafted for really good reasons after the horrors of the Second World War, to stop a repeat of the genocide and the slave labour and everything, all the other atrocities that took place in the Second World War, has now been used for, by comparison, very trivial purposes.
The court has certainly gone further than the people who drafted the convention might have expected. But on the other hand, courts are always reinterpreting the law in line with current circumstances.
No, I don't think the European Court has gone too far in its judgments, nor in sort of impinging upon parliamentary sovereignty. The European Court is very much stuck to its mission, which is simply to gauge the consistency of cases that come before it with the European Convention.
Of course the court has had to move with the times, and it's done so, I have to say, in an extraordinarily restrained manner.
You have got examples where they probably went further than was intended or expected, and one of those is prisoners' votes. It was not intended that prisoners would have the vote, and the court said that the UK's blanket ban was unlawful, a breach of the convention.
But a national parliament should have the power to decide whether or not a man in prison is entitled to have the vote. And it's that sort of thing which, to most people, is a minor question, but one over which sovereignty is important, where I think the European Court of Human Rights has gone too far, or was attempting to go too far.
When tyrannies begin, they often begin by locking people up and thereby depriving them of their vote. And the policy logic behind the European Court's judgment is that if you impose a blanket ban on voting, you effectively create the conditions in which tyrannies can flourish. You've got countries which have essentially well-functioning, independent judicial systems, and you have countries that don't. What is the European Convention on Human Rights to do in those circumstances? Is it to apply one rule for one group of countries and another rule to another group of countries? You only have to ask that question to realise that the answer is of course not.
All I'm asking is not that we should resolve from the convention, but that we should be entrusted with our own sovereignty in that matter.
So you're in favour of the convention?
I'm in favour of the convention.
And you're in favour of the European Court of Human Rights?
Yes, I'm not necessarily in favour of my country being held justiciable.
For any matter at all?
For some matter.
So I want to push you on it. So you accept that there are, let's take cruel, inhuman, degrading treatment and torture allegations by Ireland against the United Kingdom in the 1970s.
I think it would be outrageous if you were torturing suspects in Ireland in the 1970s and 1980s and we should have gone to a country.
By a court?
Yeah.
Okay,
I hope, however, that we would be mature enough to do that in this country. I believe our own judiciary would be sufficiently affronted that it would...
well, they weren't.
Well, I think they would be now.
Well...
Now, the judges of Strasbourg can't be overruled by anybody. So the question is, who should have the last word? A democratic body such as a parliament, or a court which is not accountable to the requirements of political vote winning and democracy more generally?
I mean, you need a court that is going to be independent of the people. It's been one of the great champions of minorities across Europe, whether that's gay people, people with disabilities, racial minorities have benefited enormously from the protection of the court.
I think if we had a Bill of Rights that replaced the Human Rights Act, very little would change, but it would give Parliament sovereignty.
The Conservatives published a policy paper in October, at the very end of the week of their party conference, a couple of days after Chris Gray's speech, in which they said they were going to publish a draft Bill of Rights shortly. Now, as we know, no such draft Bill of Rights has appeared.
We have a Human Rights Act that does actually reflect the Convention, it reflects our international obligations. It seems a sort of waste of effort really to mess with that.
I served on the government's commission on a Bill of Rights, and I dissented from the majority because it became very clear to me and to Baroness Kennedy, who also joined me in a dissent, that what the majority, not all members, but most of the members of the majority, in fact were doing was using the idea of a Bill of Rights to create conditions in which the United Kingdom could withdraw from the European Convention on Human Rights.
It's very hard to imagine that a Bill of Rights would be introduced that would be the Human Rights Act plus. If that were the case, then that would probably be fine, although it's very hard to imagine really which rights would change and which would be added.
So you could go back to the precise position before 2000. I think it would leave footprints in the sand. I think it would still be the case that judges, having been familiar with interpreting the Human Rights Convention, would think along those lines, but of course it meant that individuals had to go to Strasbourg in order to enforce their human rights. And that means that if that were to happen, it will take longer for people to get their human rights, and the courts of the United Kingdom will not be able to create any input into the human rights jurisprudence.
The United Kingdom helped draft the European Convention, has shown leadership as a beacon in persuading others to implement the Convention, and for the United Kingdom to withdraw, I think, would have the most terrible international consequences, not only in Europe, but also beyond, because it would sever the link with the idea that Britain is a leader when it comes to human rights and the rule of international law.
The United Kingdom would have to leave the Council of Europe. That would have political implications. It wouldn't play very well in Eastern Europe, where obviously we're trying to make a political impact on Russia and Ukraine, and it wouldn't look very good if we were to leave one of the democratic bodies that includes Russia and Ukraine.
For the UK to withdraw from that mechanism would, I think, undermine the authority of the court full stop, and would threaten the human rights of people across the Council of Europe. So there is, I think, a danger for our international reputation. It would also make it very difficult, obviously, for us to lecture others about their human rights. And we would still be bound by all the UN instruments that largely cover the rights set out in the Convention.
I would be unhappy if we were to withdraw from the Convention, because when we entered into it in 1951, we did so in good faith and with very good reason. And of course it was largely drafted by an Englishman, by Sir David Maxwell Fyfe. And its intentions were entirely noble and entirely right, and I would not like to withdraw from it. What I would like to see is a greater ability for this country to interpret what that convention means.
A Bill of Rights that's a stalking horse to get rid of British participation in the European Convention is not something I would wish to be associated with. A Bill of Rights that implements the European Convention on Human Rights in a way that departs in one way or another from the Human Rights Act is certainly something I'm entirely comfortable talking about. Reasonable people, again, can disagree on the detail, but the critical point is we must remain parties as a country to the European Convention on Human Rights and bound by judgments of the European Court.